Okay.
Good morning, everyone. I see we still have some people signing on. We'll give it one more minute. It's great to see so many of you. I can't start calling you out by name because then we'll be here forever. Hey, Scott. In case, I'll wait one more minute. It's good to see you, Jennifer. I'm actually going to be going to Hereford, Arizona in September of this year.
Well, I hope you're going to join us for our event, September 11th.
I am. I certainly am. And then driving back through Wilcox and going to Apollonie. So super excited.
Sounds fun.
Do you want to get started, Jen?
Yes, sorry. Welcome, everyone. If you haven't met me before, I'm Jennifer Blair, Director of Membership with the Alliance of Arizona Nonprofits. We appreciate you taking the time to join us today. We're super excited about the topic and our presenters, and also to get to see you again. Angela, I'm going to introduce Angela Palmer, who's our Director of Marketing.
Events and marketing.
Events and marketing. We keep adding things to her plate. Angela's going to kind of give us the overview of how everything's going to work today. And then I'll let her take it away.
Okay.
Right.
So today we are going to do 2 networking breakout sessions. So you will be automatically moved into those for about 7 minutes to meet with your fellow nonprofit professionals. Be sure to share your contact information, your name, email, the organization, etc. We also send the list of all attendees at the very end in our reminder email, which will go out either today or tomorrow. So if you miss someone's contact email, just make sure you have their name, because otherwise you might not know them when you get that list. So that'll happen twice. And then if you have questions as we're going through Michael's presentation, feel free to drop those questions in the chat as they pop up in your head. And then Karina and I will both be monitoring those and making sure that they get answered at the end of the session. There is closed captioning available. So if you need that, you can click live transcript at the bottom, and this will be recorded and we'll be sending that also in the follow-up email. Jen, anything that I am missing?
Super. I can't think of anything. And I'd like to, would you please put me in a breakout room?
Yes, you got it.
Divide us up. All right.
All right, I am working on getting everyone assigned.
Okay, and then we'll see y'all back here in 5 minutes.
5 minutes.
5 minutes.
Hold on. Okay. I gotta move Michael. Let's see. Michael, I'm making it so that everyone has to click the button to go into a room. So just don't click that button, okay? And it looks like we are good to go. So we will see you back here in 5 minutes.
See you in the breakout room. All right.
You're ready to go.
All right. It is my pleasure and great honor to introduce our 2 rock star presenters. Bob Brown. I'm sorry, I have to bring up the bios. I'm not going to read their entire bios. I'm going to kind of paraphrase some of it, but we will be sending out the full bios to you afterwards. First of all, we have Michael Edgel. Michael's the director of the law firm of Schmidt and Schneck. I practice saying this too. Schmidt, Schneck, even in Williams.
There's not very many.
In
The way
Phoenix,
I formatted
Arizona.
it, I did her name up here with the space for her signature instead of down there.
Someone's talking. There we go. An Arizona native, Michael graduated from the W.P. Carey School of Business at Arizona State University in 1998 with a Bachelor of Science in Finance. He went on to obtain his Juris Doctor degree from Sandra Day O'Connor College of Law at Arizona State University in 2001. Michael specializes in representing employers in labor and employment-related matters, including employment discrimination and harassment, wrongful discharge, breach of contract, non-competition, non-solicitation matters, social media, alternative dispute resolution, and arbitration agreements and other related areas. So welcome, Michael. And then we have Bob Brown. Bob, can you wave? I can't see any of you. So, Bob also happens to be an instructor for the Alliance Business on Board trainings. And Bob has over his 40+ year career, Bob's experience includes 5 years as a trial attorney, 35 years focusing on nonprofits, real estate, and commercial transactions. Through his nonprofit work over the last 20 years, Bob represented secular and faith-based nonprofit entities, including churches, parachurch ministries, human services organizations, rescue missions, summer camps, faith-based schools, and other faith-based and secular charities. Bob is a trusted advisor to executives, business administrators, board members, and committees. He assists in identifying risks and implementing appropriate protections for key assets of charitable organization. Bob counsels boards and leadership teams on campus development and construction, church planting, entity planning services, risk management, real estate, asset protection, insurance coverage. Got a lot on your plate there, Bob. Well, I have to get back to where I could see you. So everyone, please join me in welcoming Michael and Bob. Take it away, Michael.
Well, thank you, Jennifer. And I trust Jennifer or Angela, you'll let me know if there are any audio problems during the course of the presentation.
Yeah.
I certainly want to make sure we have a fluid experience for everybody. It is my sincere pleasure and honor to be invited to present to the Alliance of Arizona Nonprofits. We appreciate the invitation and the opportunity to connect with you all today. Over the next hour or so, broken up by a Q&A session and another breakout section, I will be presenting on the topics of Arizona marijuana laws and issues related to COVID-19 vaccines in the workplace. So we'll kick things off with the review of the Arizona marijuana laws, and I will share my screen now so you can see the PowerPoint presentation. So this section is entitled Medicinal and Recreational Marijuana, Arizona Employment Law Roundup. So what we'll be covering in this section of the presentation is basically, like I said, marijuana in the workplace. We'll be looking at 3 laws in Arizona that are relevant to the legalization of marijuana in the state and how they impact the workplace. So the first law we'll be taking a look at is the Arizona Medical Marijuana Act, which is a mouthful. I always seem to mumble over that, but it's the AMMA. And that was passed by voters in 2010. So this has been with us for a while. And this legalized medical marijuana in the state of Arizona and instituted certain employee protections, which we'll get into in more detail. The second law we'll be looking at is the Drug Testing in Employment Act. Now, this was passed by the Arizona legislature in 2011 to provide employers some additional flexibility and protections when dealing with employees covered by the Medical Marijuana Act. The protections established by the Drug Testing in Employment Act also address general drug and alcohol testing in the workplace, but our focus in this presentation will be on the medical marijuana aspects. The third law we'll be addressing today is the Responsible Adult Use Act of 2020. This was another state voter initiative law passed in 2020, and this legalized recreational marijuana just late last year. And so let's dive into the Arizona Medical Marijuana Act of 2010. So again, this was passed by voter initiative in 2010. And so employers have been living with this law for the last decade or so, so you may already be pretty familiar with it. I certainly remember when it passed and how it was a big hot topic in labor and employment law, and there was a lot of continuing legal education on the topic. So to summarize, the Medical Marijuana Act did primarily three things. It legalized and licensed growers and dispensaries in the state. It decriminalized possession of marijuana and use of marijuana for card holders. And it created certain employment protections for card holders. So we'll cover the employee protections under the Medical Marijuana Act. And essentially, to boil it down, what it did was it outlawed discrimination in employment based upon a person's status as a medical marijuana card holder. And so the law specifically states an employer may not discriminate against a card holder in hiring, termination, or imposing any term or condition of employment, or otherwise penalize a person based on their status as a card holder or because of a positive drug test. So an employer cannot discriminate against an employee who is a card holder because of their status as a card holder or because of a positive drug test. And so, of course, discrimination includes hiring, firing, and altering the terms and conditions of employment. These are the only employee protections in Arizona that specifically pertain to marijuana use. Again, I must emphasize that the employee must be a valid card holder to fall under these protections. If their card has expired or they are simply a recreational marijuana user, there is no protection. And here on the PowerPoint, I've got an example of what a card would generally look like. It's my understanding that this has gone primarily online. And so you'll be looking at digital cards if you encounter a medical marijuana card holder in the workplace. So like everything under the law, there are exceptions. And so we'll cover those exceptions. And when I say exceptions, I mean exceptions to the employer protections under the Medical Marijuana Act. So employers can discriminate where federal regulations apply to your business and you would lose money or a licensing status by hiring or retaining employees who test positive for marijuana. So again, this pertains to federal regulations and the business would lose money or licensing status. Other exceptions include use, possession, or impairment while on the job. So just to emphasize, if an employee possesses marijuana on the job and they're a valid card holder, they can be terminated for that. They can have an adverse employment action based on their possession, certainly based on use in the workplace. Again, regardless of cardholder status, adverse employment action can be taken against them. And then finally, under the influence. So they've come to work and they're impaired by the use of marijuana. Regardless of their cardholder status, they can be faced with an adverse employment action. So you may be wondering, well, what does under the influence mean? How does the law look at that? The law has defined that as there is impairment to some degree because of the use of marijuana. And the Medical Marijuana Act specifically states that it does not mean that the employer's determination of impairment is based solely on a positive drug test. So you have to have more than just a positive drug test, and that makes sense. So if you're going to fire someone who's a cardholder for impairment, you should have some other signs and symptoms of impairment rather than simply a drug test. But you can have the signs and symptoms that are then confirmed by a drug test. So signs and symptoms are fairly intuitive. They include bloodshot, watery eyes. It could be lethargy or delayed reactions, poor attention, poor coordination, memory problems, poor decision-making skills. And so just to offer an example, for a particular situation. Let's say that an employer has a random drug testing policy. So they're pulling employees at random and testing them for drugs. One of those drugs happens to be marijuana. Employee A shows metabolites and the person is an active card holder. And so typically when you're talking about marijuana metabolites, the types of tests that typically show metabolites are going to be like a hair test or a urine test. So that's all that this employer has under this particular example is random drug test. Let's say it's a hair test and it shows positive for metabolites. Now, if you haven't experienced with the urine or the hair test, that can show marijuana use going back quite a ways back in time. So it's not necessarily indicative of recent use. And in this example, the employer does not have any signs or symptoms of impairment. If they were to take action against this employee on the basis of the metabolite test alone, that would be unlawful. So there would need to be some additional signs and symptoms, again, of impairment. So let's take a counterexample. We went through some signs and symptoms. So let's say employee B shows up to work with bloodshot, watery eyes, maybe has the smell of marijuana on their clothes. They're very lethargic, they have poor attention, take any one of those signs and symptoms we talked about. The employer in that case can investigate the situation because obviously, they're showing signs of impairment and can take action against them with a drug test or without. Of course, I would always recommend that the employer have a drug testing policy and then confirm that with a drug test, because that would rule out any other potential causes that might fall within, let's say, the disability realm. But again, the employer in that instance where there are confirmed signs and symptoms can take action with or without a test. Of course, it's important to always document this type of situation, this type of investigation, put in writing what the signs and symptoms were, what you observed. That way you can better defend your position if it happens to go down a litigation road in the future. So again, regardless of their status as a card holder, employees can be disciplined for being under the influence at work, possessing marijuana at work, or using marijuana at work. And this includes, like I said, discipline up to and including termination.
Michael, are you going to talk about the application process? For example, is it lawful to inquire as to whether someone has a drug card?
Yeah, it is lawful to inquire.
And can you ask any other questions about drug use?
Certainly, if you've got some sort of reasonable suspicion of drug use, possession, or being under the influence while at work, yes, you could certainly ask those. You could certainly ask about drug use. You could ask them what, part of pursuant to an investigation in the workplace, you could ask them what's going on, and give your opinion as the employer, as to what you think is going on.
What about at the application stage?
At the application stage, I would say at that point, unless you've got some sort of signs and symptoms that maybe they're under the influence during the application process, yeah, I would stay away from asking about card holder status at that stage. That's something that can certainly be volunteered, but I wouldn't necessarily ask for it if it's. I think in that case, you're getting into a disability-related question, which would be unlawful during the application phase.
So you can't ask, for example, how many pizzas they eat a week, how many brownies they consume a day, or anything like that.
Yeah, stay away from anything that could take you down that road. However, if it is the policy of the employer to drug screen applicants, that's going to come up. I mean, they'll most likely disclose at that point that they're a card holder, if they have any sense at that point. So what happens if an employer makes a mistake, or you have taken action against an employee who is litigious or just knows how to use the legal system and wants to kick the employer on the way out of the door? So let's take the scenario. You've got an employee who you walk by their desk, see an edible wrapper in their waste bin. Um, and so you take action against them and you terminate them. What are some of the things that could come back at you as an employer? Well, it's interesting because the Medical Marijuana Act does not contain an express right of action. So, meaning it doesn't describe what the remedies are, nor does it state that a person who has been discriminated against can bring a lawsuit or a complaint. Additionally, there is no state agency in charge of enforcing the Medical Marijuana Act. For example, if there's a state wage law violation, the Industrial Commission of Arizona is in charge of investigating that. So what might you face if you are an employer who has taken action again against an employee who may or may not be a cardholder? Well, you may receive a demand letter from a lawyer. And a demand letter, if you've ever seen one before, is typically a letter from an attorney that is going to be a demand for damages in the form of payment or possibly reinstatement and any other remedies they feel like their client may be entitled to. And so obviously that is an official action by a government body. It's not a lawsuit. It's definitely something you shouldn't ignore. It's definitely something that you should advise your legal counsel and possibly, in most cases, your insurance carrier, if you do receive a demand letter. There is an attorney, a plaintiff's attorney in Arizona that I'm acquainted with who has kind of got a little bit of a niche in this area and represents people who've been fired related to marijuana issues. He's taken a number of cases to court, has gotten some legal decisions on it, gotten some legal decisions in this area of the law. And his common practice is to send a soft demand letter. And so he finds he's related that in his experience, most of the time, employees who have been terminated for these reasons and maybe wrongfully because they're a cardholder, simply want to be made whole. They simply either want to be reinstated or to get their back pay. So that's often what you would see in like a soft demand letter. So number two, you could see a charge of discrimination from the ACRD. Now, I know I just got done saying there is no state agency in charge of enforcing the Medical Marijuana Act. So the ACRD, which is the Arizona Civil Rights Division, which is a division of the Attorney General's office, they are in charge of, they basically have the authority to investigate claims of discrimination and retaliation and harassment in the workplace. They've got a work sharing agreement with the Equal Employment Opportunity Commission in that area. So you could receive a charge of discrimination from either agency. Typically when it's associated with with marijuana, you'll see that from the ACRD because the EEOC doesn't touch marijuana related complaints because it's still illegal under federal law. But the ACRD will pursue these from time to time. I have dealt with a couple of charges of discrimination that involve marijuana use. And typically it'll be tied to also a claim of discrimination under the Americans with Disabilities Act. So if you receive a charge of discrimination and if you've been in human resources, if you've been an employer for any length of time, typically you're gonna get one eventually if you terminate enough people, I guess. It's important to run that by your legal counsel and certainly make your insurance carrier aware of that if you do have employment coverage. I would also caution employers not to respond to the charge of discrimination on their own. When you do receive a charge of discrimination, you do have an opportunity to submit what they call a position statement responding to the allegations. I've responded to many, many charges of discrimination, and maybe I'm biased because I'm a lawyer and I'm in this area, but I think it's always better to get legal counsel if you can. Oftentimes it is covered by insurance rather than responding yourself. You may lose insurance coverage if you respond on your own. B, I've gotten involved after that stage and I've seen employers do it wrong and not cover everything they should have covered, maybe make a statement they shouldn't have made, and it complicates things kind of downstream. So the third thing you may encounter is just a straight up lawsuit. And so that would come under, specifically under the Medical Marijuana Act. And typically that's going to be coupled with other employment law claims that are associated to it. Most plaintiffs' attorneys aren't going to rest a complaint just on one legal theory. They're going to try and package it up with as many as they can creatively come up with. So again, some of the remedies that, even though they're not stated in statute, but have been supported by various litigation that's kind of grown out of the Medical Marijuana Act, include reinstatement of the employee, requests to rewrite policies that may be in violation of the Medical Marijuana Act, certainly back pay. So that would be back pay from the point where they were terminated up until reinstatement or some agreed to point in the future. Or if it's the case of an applicant, which Bob had brought up, let the applicant start work and maybe some period of back pay there as looking back to when they really should have started work. And again, just going back to the attorney who I talked about, who was a plaintiff's attorney, like he said, most of the people he said he encounters who believe they've been wrongfully terminated or not hired because of their card holder status are simply just looking to be made whole and to continue work. So the Drug Testing and Employment Act, this is the second statute we'll be looking at. So in contrast to the Medical Marijuana Act under Arizona law, this is an act, this is a law that was passed by the legislature. So this wasn't a voter initiative. This was the legislature's response to the Medical Marijuana Act. And you'll see, it came in quick succession to the Medical Marijuana Act, which was passed in 2010. The Drug Testing and Employment Act was passed in 2011, just 6 months after voters had passed the Medical Marijuana Act. And what it did was amend statutes concerning employer drug testing. And so what it did primarily was two things. It first expanded employer protections by creating an extra layer of protection, a good faith belief standard for employers who terminate an employee whom the employer believes was impaired while on the job or possessed or used drugs, which includes marijuana, while on the job. And we'll break that down in the next slide. The Drug Testing Act also established employer protections concerning designated safety-sensitive positions. And this is the big one in terms of this particular law. And you may have heard of this. This has been around for a while, like I said. So what this means is that an employer can discriminate against an employee who has the status of a drug user or marijuana user when it comes to safety-sensitive positions. And we'll break those down as well. So first we'll start with that good faith belief defense. Actually, this applies to both good faith belief and the safety sensitive position. So in order for employers to avail themselves of these enhanced protections, they have to do two things. They have to establish a drug testing policy in accordance with Arizona law, and they have to establish a drug testing program in accordance with Arizona law. So what this means as an employer is you have to have a written policy in your handbook or elsewhere that conforms with state law, and you have to have a program for testing employees that complies with state law. It is beyond the scope of this presentation to break it down. There are many, many elements to those policies. They're codified in state law. And if you have any questions about that, you can email one of us after the presentation. We can certainly point you in the direction of those statutes. Okay, so breaking down the good faith belief protections. So it's important to point out when we're talking about these good faith belief protections that they actually go beyond the medical marijuana issue, and they create employer protections in general for employees that are terminated for drug or alcohol use. And so what the law does is it provides a defense for employer actions taken in good faith based on the results of a positive drug test or alcohol test. It provides a defense for employer actions based on the employer's good faith belief that the employee used or possessed any drug while on the employer's premises or during the hours of employment. And it provides a defense for employer actions based on the employer's good faith belief that an employee was impaired while working on the employer's premises or during the hours of employment. Again, the statute creates a good faith defense for employers. So in theory, in the face of a lawsuit, an employer could point to their policy, again, the mandatory drug. In order for this to apply, they have to have that drug testing policy. So they could point to that policy and their good faith belief in the reason for the termination, which we just talked about, and which is on the slides here, and move to potentially dismiss a lawsuit brought under the Medical Marijuana Act, where a card holder had been accused of using, possessing, or being impaired while on the job. So in a way, it enhances by employer protections by providing this good faith belief, which was not under the original Medical Marijuana Act. So, but keep in mind, the good faith belief defense does not allow an employer to terminate an employee merely because they are a card holder or merely because as a card holder, they test positive for marijuana. Those protections are still firmly in place. However, they do strengthen the employer's legal position where the employer suspects an employee has used, possessed, or was impaired.
Michael, what are some ways that you see employers blow this good faith defense? How can we mess that up if we're an employer?
Yeah, that's a great question. So really what they were trying to do is there was some ambiguity under the original Medical Marijuana Act. And so rather than leave the standard in the hands of judges to be developed kind of willy-nilly, the legislature stepped in and said, hey, we want to protect employees that are operating in good faith. And so that's where this came from. So there wouldn't be inconsistency, there wouldn't be ambiguity as the medical marijuana card holder status kind of took off back in the 2010s. So it's pretty simple for employers. You just have to make sure you're not out to get the employee. So you're not taking action against them with the intent to deceive. You're not being reckless or malicious, or you're not being grossly negligent. So those are actually the three categories that would take you out of a good faith belief.
And would
So
a fertile place for that be in your email file? If you were looking for evidence that an employer was really acting in bad faith, might you be looking first in the emails to see what kind of, shall we say, unjudicious comments were made when what were thought to be private emails?
That's a place where, yeah, that is definitely a primary target for plaintiffs' attorneys is email.
That's the place where lawsuits go when they want to start.
Yes.
It's the breeding ground for wonderful, vicious, embarrassing depositions.
Exactly. So you want to make sure you maintain professionalism in your email communications when, I'd say at all times, but certainly when you're talking about employee investigations or employee discipline.
So referring to that guy as the old drunk or the old pothead is probably not a good idea.
Not a good idea, no. Yeah, any pejorative comments I would stay away from. And then, and on a side note, you don't want to call anybody, referring to someone as old anything could be interpreted as an ageist comment too. And, they're like, oh, wow, look, we now have a age discrimination claim. So dealing with one of those right now.
People of my generation are particularly vulnerable to creating multiple causes of action in a single sentence. I could give you an example, but I'd be kicked off the Alliance teaching faculty.
So when it comes to good faith, the legislature was good enough to define what good faith, reasonable reliance can be based on. And so that can be based on observed conduct behavior or appearance. So that goes to our example we were talking about the signs and symptoms of impairment. So observed conduct, observed appearance, observed behavior, that can be a basis for good faith. Information reported by a person believed to be reliable. And so that would be a coworker reporting something to a manager. Written, electronic, or verbal statements. So if an employee confesses to being impaired, possessing, or using on the job, that can form the basis of a good faith belief. Lawful video surveillance, records of government agencies, results of a test for the use of alcohol or drugs, other information reasonably believed to be reliable or accurate. So I just want to touch back again on the results of a test of alcohol or drugs. That inclusion of that as a prong under good faith still would not support termination for impairment at work based simply on a metabolite test. There's actually a court ruling on that point because, again, metabolite tests for marijuana look too far back. And so that's the hair test, that's the urine test. It's going to show use a month ago. And so if you rely on that alone as the basis for terminating someone for impairment at work, you're going to get yourself into trouble. So you need to have, again, some other indicia of impairment to justify that termination. So now we're going to take a look at the safety sensitive position, which again is kind of the big gimme to employees in this area, employers in this area. So the Drug Testing and Employment Act created the safety sensitive position, and it permits employers to exclude an employee from performing a safety sensitive position if the employer has a good faith belief that the employee is engaged, and this is the key part, in the current use of any drug which could cause impairment. So simply engaged in the current use. That doesn't mean at work. That doesn't mean actually impaired. It just means generally they're engaged in the current use of any drug which could cause impairment. So this is much, much broader than what is permitted under the Medical Marijuana Act. Again, it does not require use, possession, or impairment at work. It only requires current use. And this is where the legislature was really trying to rein in the Medical Marijuana Act. And so the definition of safety sensitive, again, extremely broad. And this is the kicker right here. It includes any job designated as safety sensitive by the employer, any job. So big gimme to employers in this area. They go on, they get a little more specific as they go on, but it includes tasks or duties that the employer in good faith believes could affect the health and safety of employees or others, which includes operating a motor vehicle, equipment, machinery, or power tools, repairing, maintaining, or monitoring the performance of equipment, machinery, and manufacturing, the performing of duties in residential or commercial premises of another, so off-site duties if they're going like a Cox repair person who's going into people's homes, or a salesman who's going into a hospital to try and make sales, would be considered safety sensitive. Preparing or handling food or medicine, which is another big one. Anyone on any vocation on a list of vocations under Title 32. And that's a really broad list. So just as a matter of example, some of those vocations that are listed are architect, engineer, geologist, home inspector, barbers, and it goes on and on and on. So the statute talks about excluding an employee from a safety sensitive position, right? So it says, basically, employers can't exclude these employees if the employer has a reasonable belief that they're engaged in the current use. So we can exclude them. Well, what does exclude mean? Well, the statute talks about that too. So actions to exclude an employee from performing safety sensitive positions includes reassigning that employee, taking them out of that position, putting them in another position. That's permissible. Placing them on paid or unpaid leave, presumably until they stop their current use. additional supervision of the employee to control their job performance. And in some cases, that's included. In some cases, that could be an adverse employment action. Reassignment of the employee to a different position or job duties permanently. And then the kicker, save for last, suspension or termination of employment. So based on the employer's good faith belief that the employee is engaged in the current use of any drug, whether legal, prescription, or otherwise, which includes medical marijuana cardholders, if the drug could cause an impairment or decrease their performance or ability to perform their duties, the employer can take any one of the actions that we talked about. And so again, a big exception to the Medical Marijuana Act. So some recommendations for safety sensitive positions. Although this is a big gimme, and it's pretty surprising that this has been around for 10 years and there isn't a lot of case law in this area. So the safety sensitive position has really, that big of a grab to change significantly the terms of a voter initiative law has not really been sorted out in the last 10 years. It's still a bit of a nebulous situation. So that's why I've got some recommendations here. If you're going to designate a position safety sensitive, do it in advance of action, hopefully, and in writing. So place that designation on the job description or a policy handbook, list the different positions that are safety sensitive. That'll really help support your position down the line if you run into litigation. I would say don't overuse the designation. Don't apply it to all employees if it's not warranted. Make sure there's an actual element of safety involved. Okay, make that just a rule. Hey, if we're going to designate something safety sensitive in good faith, it's got to impact safety somehow. So we're not going to make, this is always the big joke when this topic comes up, we're going to make the receptionist safety sensitive. Not a good idea unless he or she really somehow impact safety. So, maybe part of the job is to drive a motor vehicle, go take the mail to and from, the post office or something like that. Then maybe you're getting into the safety sensitive area, but don't overuse it, don't abuse it. Make sure there's a good faith reason to use that moniker for the position. Because I caution you, plaintiffs' attorneys are chomping at the bit to present a constitutional challenge to the safety sensitive carve out in the drug testing statute. You don't want your business to be on the caption of that lawsuit. You don't want to be known as the business, because they always grab one name when a case becomes popular or becomes known or significant. So you don't want your name to be on that case, and that's what you become known for in the future. So follow these recommendations. I think they make a lot of sense. And so finally, we're up to 2020, recent history here. So the Responsible Adult Use of Marijuana Act of 2020. So this act is interesting. It was drafted in consultation with business leaders. For that reason, it places no restrictions on employers. It does not create any new employee protections. It expressly states that it does not restrict the rights of employers to maintain a drug and alcohol-free workplace. It specifically states that it does not restrict the ability of employers to have workplace policies restricting the use of marijuana by employees or prospective employees. So if that applicant is not a card holder and you do drug screening for all job applicants, and that applicant comes back with metabolites or comes back with active components in their system because it's a blood test or a breath test, you can discriminate against them on that basis. There are no protections under this law for that. And again, that's non-card holders. Card holder is that status to check for whenever this issue comes up. And significantly, this law does not require an employer to allow or accommodate the use, consumption, possession, transfer, display, transportation, sale, or cultivation of marijuana. I was surprised how far the statute went to preserve the ability of employers to restrict use in their workplace. And specifically the language that employers can have policies that restrict use by employees or prospective employees, and the language that says employers do not have to accommodate use was striking to me. And so, if you've been in this area for a while, human resources, what the drafters of the law, I almost said the legislature, wasn't drafted by the legislature, but the drafters of the law, what they were going for with using the terminology of accommodate. And that was clearly aimed at issues of disability accommodations and similar state claims. So looking back, the only protections under Arizona law for employees comes out of that 2010 Medical Marijuana Act, which we covered. So card holder status is critical. Whenever you are facing a workplace issue involving a positive marijuana test, the first place to start is to determine card holder status. Just as kind of an FYI to put this on everybody's radar, there are some ADA considerations that you need to be mindful of when this issue comes up in the workplace. So be careful in situations where you learn that an individual is using marijuana for a qualifying disability under the ADA. It may or may not come up, when you're talking about someone who tests positive. They may or may not share with you why they are using. And just based on use alone is not enough to tip off that they may have a disability. So this would really be something that either know beforehand or that they disclose upon a positive test or some other indicia of use. So you just need to be cautious when the disclosure of a disability comes up. You want to make sure that whatever adverse action that may be taken is not tied to the fact that they are disabled or doesn't look like it is. So they may have the right to a reasonable accommodation for the underlying disability. This is never going to be possession, use, or impairment at work. But if the marijuana issue is tied to a disability, you want to make sure that you at least go through the thought process of potential reasonable accommodation or the appropriateness of taking some sort of adverse action against them. And so that's where you get your seasoned HR professional in the loop and do an analysis, or legal counsel in the loop and do an analysis.
Michael,
yeah.
again, does that mean we can ask about an ADA condition in conjunction with that, or we still don't ask that question either?
I wouldn't ask the question. So to engage in the interactive process to ferret out a reasonable accommodation, the disability either has to be disclosed if it's not obvious, or it has to be obvious. And so in kind of the scenario that comes to mind is if you've got maybe a random drug test, and so you're pulling employees randomly to test them for drugs, and someone tests positive for marijuana, they're not a card holder. You've got a policy against against marijuana use. If the employee at that point says, I really need it for my severe back pain, that's why I'm using it. I've never used it at work. I've never come to work impaired, but my back, it just kills me. So I need it. At that point, you've got a disclosure. So I wouldn't ask, hey, why do you use marijuana? Is it for some sort of medical issue? That's going to get you into trouble. But if you've got a disclosure, that's where these issues kick in. But just as a refresher for our smaller employers out there, the ADA only applies to employers with 15 or more employees. So if you fall below the 15 threshold, you don't need to worry about, the legal ramifications of it. There may be moral, that may be something that's important to you is to try and accommodate people. I do think that's important, but certainly there won't be any sort of legal repercussions if you fall under 15. So definitely if this comes up in the context of like I said, some sort of disability or, that red flag gets raised, make sure you just take a step back and think through those issues. Okay, looking ahead, man, things have been really interesting in this area. When you look back, we've seen dramatic increased public acceptance for marijuana. And so if you look back at 2016, when recreational marijuana was on the ballot in Arizona, it was no by 51.32%. So razor thin margin in 2016. 4 years later, the measure passed by 60%. That's a huge shift in just 4 years. And what's striking, I looked up the Gallup polls. In 1969, there were 12% of the population in favor of legalization. Last year, 68%. So whatever stigma that used to be placed on use is pretty much gone. There are huge majorities in favor of legalization. We saw it in Arizona. It's going to continue. With recreational use now legal, I believe we're going to see the number of card holders steeply decline. So it's probably not going to be an issue that most employers are going to see going into the future. Because why would you jump through the hoops to get a card unless you're really keyed into those employer protections? And that's something that you want to secure. But why go through that headache when you can pull into marijuana shop and just buy your recreational product? So so you're going to see that decrease in card holders. I do think you're going to see more of your workplace, more of your employees using, more of your employees, if you drug test, are going to be testing positive. And frankly, as it's gotten more, as the stigma has pretty much gone away, it's taken up more of the kind of status of alcohol in the community and in society. So I think realistically, if with the stigma going down, with more people using, more employees using, if you have a really strict policy, which is your right against use as an employer, you're probably going to narrow down your employment pool. So it seems reasonable to me to keep it in that kind of the realm of alcohol, treat it like alcohol. Obviously, it's up to the employer, but if someone can use alcohol responsibly after hours, it's not impacting their work. It seems to me that marijuana probably falls into that category at this point in time. So that concludes our look at Arizona marijuana laws. I think we're going to start a Q&A session.
Yes, we have several questions, and we are making an executive decision to not do the second breakout room to make sure that we have enough time for your vaccination presentation as well as all of the questions. So I'm going to hop right into the questions for you, Michael. First, is there any drug testing policy samples that you have that you could share with us?
Yes, we could certainly make that available. Yeah, I could pull that down. Like I said, the Arizona statutes are very specific about what the policy needs to include. So largely you kind of cut and paste from the statute and modify as needed.
Thank you. And then in terms of drug testing, what if an employee has an accident on the job?
Well, yeah, it's very common to test for drug use after there's been an accident on the job, particularly if you have signs and symptoms of impairment. Oftentimes there's a policy, just a strict policy that, hey, if there is an accident, we'll be testing. So whether you have signs and symptoms or a strict policy, both are considered legal. And so if someone does come back and test positive, again, if since we're talking about marijuana, I would caution you to do the I think it's called the active component test rather than the metabolite test, because like I said, metabolite, we have court decisions that say we don't look at metabolite tests to show impairment. So I would do a blood or a breath on marijuana, but certainly it's appropriate under whether you've got signs and symptoms or whether that's just a straight policy.
Okay. And then, so you recommend that over a saliva test instead?
I don't specifically know about saliva tests. I would say as long as the saliva test is going to pick up an active component, then it's safe to rely on it. If it's the hair or urine where all you're talking about is metabolite, then you need to do more.
Okay. And then if an employer requires drug testing for the job, if someone tests positive, it's okay as long as they have the card. And that's really just a clarification.
Yes. So if you have a job applicant that's a card holder and you do mandatory applicant testing and they come back positive for marijuana, you cannot discriminate against them.
Okay. And then, Jen, do you have a question? Okay. Do federal regulations override the state regulations?
In terms, there is that exception to the medical marijuana law that states that if federal regulations apply to an employer, such that if they hired a current drug user or someone who tests positive, that they would either lose income or lose licensing, then the federal statute would trump at that point.
And then if an employer falls under federal regulations, can they act on a positive test alone, or do they still have to adhere to the state regulations?
Can they ask if they're a card holder? Is that?
I think it's that if they are doing testing and they find that someone tests positive, but this employer is technically a federal employee, then can they be fired for that positive drug test, or do they still have to adhere to the state regulations of whether or not they have a card?
If I'm understanding it correctly, so if there's some federal requirement that they can't hire someone who tests positive or is a current user, then the federal law would control there. They do not have to abide by state law.
Thank you. And then the last question we have is, we do have some people asking about safety sensitive positions and whether or not that's applicable to animal related organizations. Based on how you explained it, it's really about the function of that role, correct?
Correct. And I believe that under Title 32, which was that list of different vocations, I believe that veterinarian is listed.
Okay.
So
can you send us that title so that we can share that with our attendees?
Sure.
Thank you. And that is the last question that I have. So if you want to move forward with vaccinations, please do that thing unless Jen has something else to ask.
No, I'm sorry. I realized I took myself off mute. So please carry on. This is fascinating.
Okay, great. We will charge right through. So we're now going to switch gears to COVID-19 vaccinations and human resources implications. So in this presentation, what we'll be looking at are the current, basically the current employment law landscape regarding COVID-19 vaccines. And I say current because it seems to be changing day by day. Employee protections that have been recognized regarding vaccine policies, and employer responsibilities regarding employee privacy and confidentiality requirements. I'll also be making some general recommendations on this topic. So the big question in this area has been whether employers can require employees to be vaccinated. If you've been watching the news over the last week in particular, you'll probably know that the answer is a resounding yes at this particular point in time. We'll get to how that may change, but right now it's a yes. And that is based on the Equal Employment Opportunity Commission guidelines in this area. And the guidelines have been out for the better part of a year on the issue of vaccines, saying yes, employers can mandate vaccines in the workforce. There are, of course, some exceptions. And so those exceptions are any sort of disability concerns or religious concerns on the part of the employee. And so really what that comes, I said concerns, but really that is a claim of disability on the part of the employee, or the claim from the employee that it would violate their religious beliefs to be vaccinated. And so, like I said, this can be a shifting landscape. And this part of the presentation is based on the EEOC guidelines, because that's all we have right now, because it's such a new issue. EEOC guidelines, just a caveat, aren't always the final word on an issue, because the EEOC is just, it's kind of like the police department for employment claims. That's kind of how I think about it. Their job is to investigate employment claims. So discrimination, retaliation, harassment. So they investigate. I won't get into all the procedural ins and outs, but that can then be advanced to court. And so then you have a judge, a federal judge, most of the time, who's going to be sitting and interpreting the laws that the EEOC is trying to enforce. And so it wouldn't be the first time that a federal judge has thrown out EEOC guidelines on a particular issue. That being said, I would expect federal courts to uphold this vaccination guidance, given the extraordinary public health crisis that we've all been going through, and the fact that this is supported by public health officials, state and federal governments, and the efficacy of vaccines has been shown to reduce the rates of infection and the severity of the illness. So again, an employee can raise a disability-related objection to receiving a vaccine. They can raise a religious-related objection to receiving a vaccine. In either case, the raising of such an objection requires the employer to engage in the interactive process with the employee to determine if a reasonable accommodation is appropriate. So if you've dealt with the ADA issues before, you know that when a disability comes up, that the employer must engage again in the interactive process. This is a back and forth dialogue with the employee to determine if there is a reasonable accommodation that would permit the employee to perform the essential functions of their job. To invoke the interactive process, an employee does not need to use specific words. So they don't need to say disability. They don't need to say reasonable accommodation. They don't have to make a specific request for a reasonable accommodation. It's up to the employer to identify when an employee is invoking the ADA. So it's up to that human resources person, that manager, to recognize, because of training and experience, oh wait, this is an ADA issue. I better slow down. I better get some people involved to analyze this issue and go through that interactive process. So what is a reasonable accommodation? Well, it's a workplace modification to allow a person with a disability to perform the essential functions of their position. So when you're talking about an employer policy that implicates an employee's disability, in this case, for our discussion, it's an employer policy that says all employees must be vaccinated. When you're talking about that, when that comes up again, take a step back and kind of the first place you start is, hey, does our policy, does our vaccine mandate, does it meet two requirements? Is it job related? And is it consistent with a business necessity? That's really where you start. Is this a reasonable policy to be, mandating across the entire workforce or across this entire class of employees? So that's where you start. Some examples. So let's say, over the last year and a half, it's not uncommon for telemarketers or, tech support, phone support personnel to have gone home and work from home. because they just need a chair, a computer, and a phone. They can get that at home. And my understanding is a lot of that workforce is going to stay at home. And so if you have a vaccination policy that applies to that workforce, is that job related? Is that consistent with a business necessity? I would say no. So again, when you're looking at this policy, when you're looking at possible disability claims or religious claims, that's where you would want to start. A counter example would be, let's say you've got a nurse who works, you've got a nonprofit, you're serving the community, you've got a clinic, so you've got a nurse there. The nurse is a frontline medical professional who is going to be interacting with, a great number of the public who maybe, needs medical services, dealing with people who are potentially ill. A policy requiring that employee or that category of employee to be vaccinated makes a lot of sense, because it's going to be protecting them and it can be protecting the public as well. So I would say that that would be consistent with a business necessity, and that would be job related. So that would get you over that initial hump. So that's where you start when you're looking at these policies. So some exceptions, there are always exceptions. The ADA is no different. And if you've been in this area for any period of time, you know that the ADA requirement to reasonably accommodate a person with a disability does not apply if it would present an undue hardship to the employer, or if the accommodation would present a direct threat to the employee or to others. And so we will break that down. Under the ADA, an undue hardship is any action that fundamentally alters the nature or operation of the business, or is unduly costly, extensive, substantial, or disruptive. In this area, it's extremely difficult to come up with hard and fast rules. Again, when it comes to undue hardships and accommodations. And it's because this area of the ADA is very, very fast specific, and it's different on a case-by-case basis. You can think about a mom and pop shop that has one location, and what would be unduly costly for them would not be unduly costly for a Walmart. So that analysis, again, case-by-case basis, really hard to come up with examples, but so that's the undue hardship analysis when it comes to reasonable accommodation. So the second exception would be a direct threat. So direct threat means a direct threat to the employee or to others in the workplace. And that can be the public, it can be fellow employees. Direct threat is defined as a significant risk of substantial harm that cannot be eliminated by the reasonable accommodation. So a good example, as I recall, there's a case on this point, is that you've got a train operator who's got a neurological disability that causes seizures that cannot be controlled by medication or other means. Clearly, this would present a direct threat, not only to the operator, but to the public and other employees. When it comes to the subject of mandatory vaccines, if an employee declines the COVID-19 vaccine because of a disability or health concern that may give rise to disability-related legal protection, under this area of direct threat, the employer must determine whether there is a significant risk of substantial harm from not receiving the shot, and if so, whether there's a reasonable accommodation that would reduce or eliminate that threat. Again, this would be a fairly easy case to make for the frontline medical worker, that there isn't really any way to accommodate this. We'll look at what some different accommodations are, but in terms of accommodating them by merely having them wear a mask or protective gear may not be enough. There would be a direct threat to this worker or patients if that person wasn't vaccinated. So going back to the detailed guidance from the EEOC on the topic of direct threat, employers should consider when they're weighing this particular exception to the ADA and a reasonable accommodation is the frequency or duration of the objecting employee's direct interaction with others. That's going to be a big one. The number of partially or fully vaccinated persons in the workforce. Whether other unvaccinated staff wear face coverings or undergo routine testing, and available space for social distancing. So this is taken right out of the EEOC guidance. This is what the EEOC wants you to look at on the topic of direct threat. If you've got an employee in the workplace who says they have a disability, so they can't be vaccinated. These are the kind of the minimum that you should look at when weighing that, whether an accommodation would be appropriate. Finally, if an employer is going to rely on the direct threat exception, it must be based on reasonable medical judgment that relies on the most current medical knowledge about COVID-19. So it can't be just speculation. It can't be guidance that came out 6 months ago. You've got to be continually checking in and making sure that you're relying on the most recent guidance. And man, it can be confusing. I mean, just yesterday, the CDC changed their recommendation on masks again. And from what I can tell, it was based on some new studies that show, I believe it was with the Delta variant, that even if you're vaccinated, you still contain a significant viral load, which means vaccinated can now spread to unvaccinated, which a couple months ago, they're saying, hey, if you're vaccinated, your viral load is low. And so the chance that you're going to transmit to an unvaccinated person is extremely low. So take your mask off, you know? So now there seems to be some backpedaling. And even in some of the reading I did on that kind of new policy, which is or recommendation that came out yesterday, not a policy, it's just a recommendation. It talked about in that article, you know, maybe that higher viral load is actually dead. I think they call it viral components. So it's been broken down, but it's still registering as a high load. Is that transmissible? Is it not? You know, this is all to emphasize that, hey, if you're going to rely on this, if you've got such a policy, the direct threat issue comes up, you got to rely on the most recent guidance. And that is a shifting landscape, to be certain. So what are some reasonable accommodations in this area? Well, we go right back to that EEOC guidance. So face masks, social distancing, a modified schedule. So if you've got a vaccine policy, you've got someone with a disability. And the most common thing that comes up is someone who's immunocompromised. So they've got a compromised immune system and they might have health concerns if they take the vaccine. So a modified schedule might be something that an employer offers to that person. So have them come in after hours when there aren't as many employees around. Obviously, work from home would be an option. Enhanced screening or testing of the, I would say, at this time, unvaccinated employees to make sure that they're not coming into the workplace with an active infection. And then as a last resort, and this is always a last resort under the ADA, is reassignment to another position. So after you've ruled out all the other accommodations, you should look at reassignment, and if that would be appropriate. If there's not an open position, though, you don't have to create a position for somebody. And as it states on the slide, the EEOC recommends that if you're going through the reasonable accommodation interactive process, that there's a resource called the Job Accommodation Network. You can just Google it, and it can take you through and give you examples of that process and offer. They've got a special COVID-19 section that kind of takes you through different accommodations that might be appropriate or reasonable. So the EEOC has said, because this has come up a little bit in the marijuana discussion, that requesting documentation or other confirmation of vaccination is appropriate. So you can ask employees that. It's not considered a disability-related inquiry under the ADA, which would be a big no-no. So it's not that. You can ask the question. So employers are free to ask employees if they have been vaccinated. However, it's not really a caveat, but there's an extra step you have to go through. If you receive documentation or information about an employee who has been vaccinated related to their vaccination, that is considered medical information and it must be kept confidential. So if you have a copy of the vaccination card for employees, you've got to keep that as confidential medical information, keep it separate from their employee file. Okay, so we'll switch gears slightly to a religious objection.
Michael, before you go there, does that mean HIPAA would
Yes.
apply to that information? Or is it just a simple standard of confidentiality?
It would be a simple standard of confidentiality in this case, since we're talking about employees. And so typically the recommendation is don't keep it in the employee file, keep it in a separate medical file. So on the topic of religious objections, a religious objection must be based on a sincerely held religious belief, practice, or observance. It is generally best practice for employers to assume that an employee's request in this area is sincere, and that rather than questioning the sincerely held religious belief. Unless you've got some reason to suspect that they may be being dishonest. So if the employer is aware of a fact or has some basis again for questioning the sincerity of the religious nature or the belief, the employer can request additional supporting information. So I just kind of always think of, if you've got that employee who's maybe, politically opposed to vaccinations and wears it on their sleeve, and all of a sudden they come in and say, oh, I'm XYZ religion and it's against my religion, I can't do this. But the employee's never talked about that before. The employees never observed the religion, never asked for certain days off. You've got, like I said, a good faith belief for questioning it. You can ask for more information. There is some leeway there. But generally speaking, if you don't have some sort of good faith basis for questioning it, you should consider it sincere. Requests for religious accommodation do fall under that reasonable accommodation standard. I say that, but actually it's specific to this, to religious observances. So it's not the same standard as under the ADA is what I'm trying to say. So when you're weighing a religious accommodation, it's actually a lower standard than the ADA. And so under Title VII, which is where this falls, a religious accommodation is not required if it would impose more than a de minimis cost on the employer's business operations. So again, a much lower standard than the ADA. And so if it's more than a de minimis cost, it's not something that the employer necessarily has to do. And so by way of a ridiculous example here, masks would be de minimis. Masks are pretty cheap. It's basically, an OSHA standard at this point to offer masks in the course of the pandemic. However, installing a hyperbolic chamber would not be required. And that's far above de minimis. Again, this is fact and case specific. It's difficult to have hard and fast rules without really taking a look at what the work environment is and the financial position of the employer. But that's the general standard. It is less than the ADA. So that is the religious accommodation. We'll move on to confidentiality requirements. We've touched upon it a little bit. We've already touched upon the fact that yes, an employer can ask for proof of vaccination. That's not prohibited. However, the confidentiality requirements are there. You do have to keep it in a separate file. Typically, what is considered confidential medical information is diagnosis information, treatment information, which would be vaccination, and requests for accommodations. So you've got to keep that confidential. So we did talk about how it is currently legal and is to ask about vaccination status. You may have noticed in the news that several states are taking action to make that illegal. That includes the state of Arizona. So there is a Senate Bill 1648, which when I looked it up this morning for an update, it indicated that no action had been taken since February. But keep your kind of ears peeled to the news if any action comes forward on Senate Bill 1648, which prohibits discrimination in the workplace and elsewhere against individuals who have not received or refuse to receive a COVID-19 vaccination. So as it stands right now, the bill would prohibit any employer from requiring a person to receive or disclose whether they have received a COVID-19 vaccination. So I'd basically throw out everything I just said, but it's not the law yet. So right now, what we talked about is the current state of things, but again, it's shifting. So other states have made similar moves. So keep this in mind. Keep your eyes on the news in case this does advance. There are some other aspects to it as well that would prohibit any business or public space from limiting access to a person on the basis of their vaccination status. So it would, it's basically to protect the privacy of people who don't want to be vaccinated. So we'll have to keep our eyes on that. Certainly if that does come and is passed by the legislature, signed by the governor, I would email Jennifer and try to get you, this list, generally the members of the Alliance, an update on this so that they're made aware of it. I would reach out if that does come to pass. So the EEOC, kind of in wrapping up, right now the guidance does suggest that employers can apply different rules to vaccinated and unvaccinated people, which includes masks, forgoing social distancing, and forgoing screening that may be taking place in the workplace. Again, if that Senate bill passes and is signed into law, this guidance would basically not be applied, and you'd be held to the non-discrimination statute passed by Arizona, if that does come to be passed. So my recommendations right now would be not to mandate vaccines unless the workplace really has an elevated risk of transmission. Whether or not that's the case, I would look to CDC guidance or some sort of medical recommendation on whether or not a workplace has an elevated risk. I would encourage vaccinations without political activism, try to take it out of the realm of politics. That seems to poison those conversations. And in encouraging that, include paid time off for shots or side effects from shots. I think the rate of side effects is at 30%, like between 20 and 30%, so it's not insignificant. I know people have had side effects. I was vaccinated and I had side effects after my second shot. I felt horrible for a day. Again, respect objections based on a disability or religious, sincerely held religious belief. Foster positive communication on the topic in the workplace to the extent it doesn't become disruptive. You don't want to make every conversation about it, but get the positive and scientific information out there. Protect confidentiality of medical information like we talked about, and strive for fairness. So with any sort of legal presentation, we do have to have a disclaimer. So what we've presented here is not specific legal advice. It does not create an attorney-client relationship. This is presented for informational use only. And if legal or other expert advice is required, we do ask that you contact us for that. Again, specific legal advice. And here is our contact information. So if you'd like to reach out, our contact information is available there, and I understand it'll also be distributed with our biographies. So I appreciate your attention to this. I know I think we finished on time. So
we have questions.
We do have
Okay,
questions.
let's turn to questions.
There are questions, Michael.
But we'll be snappy about those questions. Okay. So when you talk about religious concerns, would someone simply have to say that the vaccine goes against their religion? Or should there be something more to verify that their religion does not allow a vaccination, such as religious texts, etc.?
Yeah, you can do follow-up, and so you can explore that with them. And I would say it's probably a case-by-case basis. If you've got someone who you think, you have some reason to believe that it isn't a sincerely held religious belief based on your knowledge of your history with them, you can ask for more.
Great.
So yeah, you can ask them to point out some sort of justification for it.
And that's kind of a common sense issue. So if the person says, yeah, I'm a church of the wild chickens, and our shaman has said no to the vaccinations, you probably have got a good faith basis. On the other hand, if they say, no, that's the mark of the beast, Revelation is umpty-ump, and it sounds like they actually know what a Bible is, or the Torah or whatever, then you kind of say, okay, well, that sounds like a good faith basis. And it's a sensitive enough area that if you really if it's important, it's one you might even consider seeking guidance about legally, if for some reason it's an important discussion.
Thank you. So some people on the call have been told that because they have less than 10 employees, both disability and religious exemptions don't apply to them, and that they can actually mandate all of their employees. Is that true?
Yes, if they have under 15 employees, Title VII and the ADA do not apply. So you do not have to accommodate.
Great. And then can we require new volunteers to be vaccinated before they join volunteer trainings?
I would say yes, the same would apply. I would apply the same analysis. But volunteers aren't going to be covered by the employment laws because they're not considered employees.
Okay. And if we're requiring vaccinations, can we require proof of vaccination?
Yes, you can ask about it, and you can ask for verification, but that record, whatever it is, the verification, whether it's a card or note from a doctor, is confidential.
Okay. So if an employer requires unvaccinated people to wear masks in the workplace, how can an employer manage that, knowing who and who isn't vaccinated? And if they don't wear their mask or take appropriate action, can they then take action of, say, writing them up and potentially moving into termination?
Yeah, there's a lot of issues there. Currently, you can treat vaccinated and unvaccinated employees differently, which means wearing masks. I've seen in the news just over the last couple of days, they're talking about badges as well. So some kind of sticker or badge. Right now, that would be permissible. In terms of terminating someone for not wearing a mask, you could do that if that's in a policy, yes. I would also want to rule out any sort of disability claim from that employee. So maybe they say, I can't wear it because of a lung condition. So then you'd have to kind of go through that process with them on that issue as well.
Perfect, thank you. And you already answered one of our questions, which is that some workplaces are requiring name tags that show vaccination status. And you just confirmed that that can be done at this time. Okay, so can a complaint be filed by an employee if they feel a workplace is not adhering to the guidelines you mentioned, like not wearing masks, not social distancing, etc.?
So that that would typically arise under, the way I conceptualize it, like under OSHA. Right now, OSHA does not have any specific regulations for the workplace. They just have guidance. There are certain general recommendations for the workplace. basically a general duty to keep a workplace safe, and that includes from viral infections. So, I mean, technically you could report something under OSHA if it was severe enough. I don't know that they would take action at this point, but it's possible. But I would really look towards, what are the policies of the workplace, and are they reasonable given the CDC recommendations and the best kind of medical recommendations that are out at that time. So, for example, just going back a few months ago, the CDC was saying basically, look, if you're vaccinated, your rate of the possibility that you're going to get sick is very, very low, and the possibility that you can transmit the virus is very, very low. And so a lot of workplaces at that point said, well, masks are no longer required, but you can wear a mask if you want to, because they don't want to wade into the vaccination issue. Go get vaccinated if you want to. We'll give you the time off. But really comes down to personal responsibility in some respect at that point. That, hey, you can wear the mask if you want to wear the mask, regardless of your position, if you're unvaccinated, to protect, if you think that's important for your personal health and safety. But we're not going to require the vaccinated folks to do that. And we're not going to check who's vaccinated and unvaccinated, because it tends to just the risk just tends to flow in one direction, and that's the unvaccinated. And it's a personal decision, so they can go do it if they want to, and they can wear the mask if they want to. That seems reasonable to me.
Okay. Can you confirm, is it currently true that schools and school districts are not allowed to mandate vaccines per Ducey's recent acts?
I guess we'd be looking maybe the executive order.
Yeah.
From April.
Mm-hmm.
I haven't looked at that. Let me see.
You can take your time after this and send us resources if you have something.
Okay. Yeah, I haven't specifically looked at that recently, but I'd be happy to look into it.
Thank you. And then the last question we have is, if we implement a mandatory vaccine policy and the Senate bill passes, might there be any liability for the employer who perhaps terminated an employee prior to the bill passing?
I guess we'd have to look at whether or not I'd be shocked if the bill had any sort of retroactive liability. So I would say, at my understanding of the situation right now, no.
Perfect. Thank you. So that's all the questions that we have. Please remember, we'll send out all of the contact information of everyone who's attending, as well as Michael and Bob. Thank you so much to the two of you for answering our many, many questions and giving us a ton of really great information that I think all of us have been asking. Really quickly before you go, our conference starts next week and we are hitting a ton of HR issues. So if you are an HR person, please attend. We have lots of DEI, lots of HR. There are learning sessions for literally every single person in your organization. So I highly recommend it. Karina dropped the link to that in our chat. So if you have questions, let us know. Also, we did put a link to a short survey. Those surveys are really important to our funders and our presenters and us. So please be sure to complete that. Anything you want to add, Jen, before we log off?
No, you covered it all. Thank you. Thank you all so much. I can't wait to see you at our next event.
All right, and we'll talk to you all later.
Bob, Michael,
rest
you're
of
just
your day.
Told them you were rock stars.
Bye, everyone.
Bye-bye.